you all for joining us this morning. I'm Dr. Sumi Raghavan, and I'm the co-chair for this event. And I want to welcome you to the 7th annual multidisciplinary conference hosted by the College of Humanities and Social Sciences here at William Paterson University. I want to take a moment to welcome and thank all the senior administrators who are joining us this morning and the College of Humanities and Social Sciences for their generous support in helping us put forth this conference every year. As its name indicates, this is an annual event hosted by our college, and its purpose is to bring together experts from different disciplines to give perspective on a single significant topic. The title of this year's conference is When We Speak: Sex, Power, and the #Metoo movement. This year's discussions will explore concepts of power, gender roles, and sexual behavior, and give us a great opportunity to see how the disciplines of our college complement each other. At this point, I ask that everyone please silence their cell phones. And while the sessions are in progress, please refrain from audio or videotaping or flash photography. Our event is being videotaped, and it will be available online to the public in the near future. Although we've asked you to silence your cell phones, we do encourage you to post on social media, tweet and Facebook about our event with the #WhenWeSpeak. So we've called our conference When We Speak because in recent years, an unprecedented number of individuals have spoken, publicly and directly, about the interaction of sex and power in their own lives, igniting a wave of activism, protest, and counter-protest. From a president who said, "When you're a star, they let you do it," to actual stars like Ashley Judd and Alyssa Milano, who said, "No, we don't, your time is up." It seems the voices have begun to crescendo. Indeed, Time magazine named the Silence Breakers as their illustrious Person of the Year in 2017, highlighting the undeniable cultural impact of the brave women and men who came forward to speak about the ways in which they were victimized by those in power. Over the past year, these issues have been at the center of an unprecedented discussion about the politics of sexuality in structurally unequal relationships. In recent weeks, as the modern #MeToo movement approaches its first birthday, Americans witnessed the confirmation hearing of Supreme Court Justice Brett Kavanaugh, who had been accused of sexual misconduct by Professor Christine Blasey Ford. Senators from both parties acknowledged that her allegations were credible and her pain palpable. Justice Kavanaugh passionately defended his character and behavior. When the Senate hearings were over, Kavanaugh was confirmed to the Supreme Court by a narrow margin of 51 to 49. Scholars and pundits describe this moment as a referendum on the #MeToo movement, although some argue that despite this confirmation, the outcome of that referendum is still not entirely clear. As a clinical psychologist and psychotherapist, I've worked with survivors of assault and violence who describe the experience of feeling triggered and re-traumatized by events in the public eye. As a woman in the world, I have yet to meet another who does not connect to this movement in some way. Because it is power, not sex, that lies at the core of these conflicts. Who has it, who doesn't, and how is it leveraged? We wanted to approach these debates from multiple perspectives and consider this incredible cultural moment while imagining ways to create lasting change. Our first panel is titled Looking Back: Histories of Sexual Violence, and it will explore the ways in which these questions have been viewed over time and across the globe, and will provide us with some historical context with the issues before us. Before we begin this panel, I'd like to invite the Dean of the College of Humanities and Social Sciences, Dr. Cara Rabbit, to come forward to formally welcome everyone to the conference and to the university. Dr. Rabbit, please join us. Thank you.
Thank you. It is truly my honor and pleasure to welcome you to the 7th Annual Context Conference of the College of Humanities and Social Sciences. As you heard, this is an annual event in which we gather as a community, students, faculty, administrators, community members, alumni, to reflect and engage in dialogue on key issues of the day. The conference committee members have been working diligently for over a year to bring today's events forward, and each year this group of dedicated faculty members of the college under the leadership of Associate Dean Wartina Davis come together in the fall. They'll start in November for next year, and think of a topic that might be timely, might be significant, might give an opportunity for broad-based reflection and engagement. And it seems like every year they have a little looking glass into the topic that's coming forward that will be major headline news by the following fall. Last year we looked at fake news. This year the hashtag Metoo movement. And I think that we can all agree that these are key questions of our day, and that as academics from across the humanities and social sciences, it behooves us to reflect, engage, step back, and talk about some of these key issues from different perspectives. I want to take one moment before I move any further on to just say how incredibly significant the work of this conference committee is. You just saw one of the two co-chairs, Dr. Sumi Raghavan. The other co-chair is Dr. Maria Villar. Also on this committee are Judy Bernstein, Mark Ellis, Emma Haney, Navia Gill, and of course, Wartina Davis. They have been working every week, sometimes between meetings every week, to bring together today's events. With you, I'm eager to learn more about the Metoo movement. It's not something that I have studied, but along with probably most of the people in this room, I've been riveted by the stories coming forth in the news, these confluences of very private stories of sexual assault and harassment with very public revelations of abuses of power. This is a movement that started, that I recall first seeing in a Facebook status of a friend who changed her status in spring 2017 to Me Too. And she reposted what was then a viral quote from one of the actresses aforementioned. And I quote from that: "If all the women who have been sexually harassed or assaulted wrote Me Too as a status, we might give people a sense of the magnitude of the problem." Within days, that had exploded. Hundreds of thousands of women across the country and in different sectors added their name to that list. My friend, most of her friends, me too, we all put our voice into that count. And it felt sort of oddly a little mundane, the Facebook status post, and also very, very powerful. And since then, we have watched from Hollywood to the Supreme Court, from corporations to universities, a cumulative impact of the count of these voices coming forward. When we speak is that topic. It is what happens when people take voice. In this case, around the Me Too movement, but that power of voice is incredibly significant in many different areas. According to our mission, the College of Humanities and Social Sciences is committed to providing insight into the past, critically examining contemporary issues, and exploring answers for the future while promoting the value of diversity. The space of this annual conference, this packed room of people, offers an important means for us to both celebrate and accomplish these goals. I look forward to engaging with you today in key questions for our current context, and I really thank you for joining us.
getting my exercise this morning. Thank you so much, Dr. Rabbit, for those words. So, we are very lucky to have with us in our morning panel 2 speakers to help us navigate these issues. Would Professor Greta LaFleur and Professor Durba Mitra please join us at the front table? Professor Greta LaFleur focuses her research and teaching on early North American literary and cultural studies, the history of science, the history and historiography of sexuality, and queer studies. An assistant professor of American Studies at Yale University, LaFleur's research has been supported by fellowships at the Massachusetts Historical Society, the William Andrew Clark Library at UCLA, and the John Carter Brown Library at Brown University, among others. And we are very pleased and grateful to have her with us. Professor Durba Mitra works at the intersection of feminist and queer studies, an assistant professor of women, gender, and sexuality at Harvard University. Her research and teaching focus on the history of sexuality, the history of science and medicine, and women and gender in the colonial and post-colonial world. Mitra's research has been supported by fellowships at the Penn Humanities Forum at the University of Pennsylvania, Bowdoin College, and as a Fulbright Nehru Scholar to India. Welcome, both of you.
Should I stand up and give the talk on the podium?
Yeah, I think that would be helpful.
Can everybody hear me? Thanks. So hi, everyone. I want to begin by saying how glad I am to be here, and by thanking everyone who did the work of getting me here today. So including Sumi Raghavan, Emma Haney, Dean Mortini Davis, and Maria Villar. But I know that there was a bigger committee that did the work of putting this entire event together, and I also want to thank the other presenters who we'll be hearing from today. I know how much work goes into organizing an event like this, and I thank all of them for making it happen. So today I'm going to talk to all of you about some of the history that I think informs the Metoo movement. I'm an early Americanist. This means I work primarily on the 18th century, so the period between 1700 and 1800. And so anytime that a new cultural movement emerges, or anytime we see a new interest in or way of talking about a problem like sexual violence, my first questions are always, first, what in this moment has allowed for this change to occur? 2, what frameworks are we using to understand this problem now? And are these frameworks different from or similar to frameworks we've used to address this problem in the past? And finally, how is the way that we're addressing the problem in this moment similar to, related to, or different from previous ways that we've addressed the problem? Basically, what I try to do in these moments is to think about their historicity, what came either slightly or a long time before them that made them possible. One of the best things about being a scholar who works on a time period that's quite distant from our own, so like I said, I work on the 18th century, is that thinking historically can help me denaturalize the assumptions, logics, or ways of thinking that guide, but also sometimes limit, the ways that we understand our own moment. It allows us to situate our responses to the questions and realities of sexual violence now in relation to the many different approaches that people, and largely women, have developed to address sexual violence in the past, and see how these responses have changed. Because cultural responses to sexual violence have always had a vexed relationship to the law, my presentation today is going to look at legal history alongside cultural history to talk about the problem of sexual violence. And specifically, I'm going to talk about one very widely publicized late 18th century rape case and use it to point out some of the ways that public conversations about sexual violence and the laws that guarded them have been organized around putatively preventing certain forms of sexual vulnerability while also producing others. My big argument here is that I want to shift the conversation, especially when it comes to thinking about the history of both legal and cultural responses to sexual violence, away from the language of perpetrator and survivor or criminal and victim, and think instead about the way the law works in step with structural hierarchies like racism to produce different kinds of what I call sexual vulnerability. What I'm ultimately going to argue in this presentation is that we have historically recognized only some types of sexual vulnerability, especially that of white women, and right now, that of white women who do particular kinds of work. So if you think about the Me Too movement, for example, we see a lot of this happen in what is often called the professional sector, entertainment, higher education, etc. By shifting our lens to think about the production of a diverse array of types of sexual vulnerability, especially in the face of the law, we see the Me Too movement and its many historical predecessors from a new angle. And I don't think I need to say this because we're already at a conference organized around sexual violence, but I do want to offer a broad content warning about my talk, which includes descriptions of sexual assault, as well as explicitly racist and sexualized state violence. And one final note, I want to be clear that I'm not here to criticize the Me Too movement or to undermine claims about how the structures of our jobs or our social worlds provide the ground for the exploitation, sexual and otherwise, of many people, women and feminine people, poor people, people of color, and children. The talk I've prepared for you today actually starts from a place that acknowledges the realities of just those structures of power. But what I want to do is think about what conversations about sexual violence in our own moment have emphasized and what they've also left out. So the case study that I want to share with you today, I think I just lost my clicker already, so quick. Here we go. The case study that I want to share with you today is that of Joseph Mountain, who was a free black man who was convicted of the rape of a white woman and executed by the state of Connecticut, in New Haven, in fact, which is where I live, in 1790. A little background on Mountain. Mountain was no ordinary man. He was for a time one of the most infamous highwaymen in England. So for those of you who do not spend most of your time reading 18th century histories, a highwayman was someone who committed highway robbery. And so I don't know if you've heard maybe your parents say something like, that's highway robbery, when they're talking about something that's very expensive. So he was someone who committed highway robbery, which meant that highway robbers would hang out on or around major roads that connected various towns in England and the United States. They would wait for travelers to come along and rob them, usually at gun or knife point. This was during a time where travelers moved less quickly. There were no cars, and wealthy travelers would have been on horseback or in carriages, while poorer travelers would have simply walked. This will be less familiar to us now, but it's also it's important to understand that in the 18th century, the highwayman was also sort of something of a romantic figure or a folk hero. I don't know if anyone's read or seen the Anne of Green Gables series or movies, for example. I may be dating myself by saying this, but you may recall, if you have, that Anne gives a very impassioned performance. She does a reading of a long poem called The Highwayman to her reading circle, and people are very taken with it. So Joseph Mountain, however, was not born a highwayman, and he neither started nor ended his life in England. He was born July 7th, 1758, in Philadelphia, and he was raised an indentured servant in the house of Samuel Mifflin, a wealthy Presbyterian. Samuel's son, Thomas, became the first governor of Pennsylvania in 1790, so we're talking about wealthy people here. Importantly, Mountain was taught to read and write, which was unusual for any bonded laborer at that time, black or white. And by bonded laborer, I mean that can mean enslaved people or indentured people. So indenture would mean that you would be under the control of your master for a particular limited amount of time rather than your entire life. So Mountain's father was a mulatto, so this is what the language of the text itself, so a mixed race person living in Philadelphia, and his mother was a former slave. Mountain left Philadelphia in 1775 at the age of 17, having petitioned his master to allow him to work aboard a ship. Granted permission, Mountain sailed to London, promptly deserted his ship, and it is in London that his story truly begins. So Mather's narrative is quite fun to read because of how unapologetic it is. It was enormously popular in its own moment. So you can see here, I have several editions or frontispieces from several editions of this text. So there's this one. There's this one. This one is missing the cover, but it is a different edition. There's this one, and there's this one. But there's actually more editions that I'm not even sort of showing you the covers for here. So his narrative was enormously popular in its own moment, in part because it was basically the 18th century equivalent of the genre of writing or television that we now call true crime. He relates in quite a lot of detail his various exploits as a highwayman. In each edition of Mountain's narrative, so this is printed in 1790, and these editions vary in length from roughly 12 to about 32 pages, the reader follows Mountain as he robs ostensibly hundreds of people, and furthermore robs them with style. Mountain is very much a highwayman of the British print tradition. He's a folk hero, and his story is an adventure tale. Daniel Williams argues that the popularity of Mountain's narrative derived from precisely its generic novelty, arguing that, quote, readers had never before encountered a character like Mountain. He was the first English highwayman shaped for an American audience, and he was the first to so clearly embrace his outsider status. In a particular memorable episode, just to give you a taste of what this looks like, while he's riding through Warrington searching for potential, quote, objects of plunder, Mountain came across a gentleman and asked him for the time. The gentleman, quote, drew his watch and told me the hour. I observed, you have a very fine watch. He answered, fine enough, and he said, and Mountain responds, sir, 'tis too fine for you. You know my profession, deliver. So deliver, he's saying, give me your watch. The gentleman remarkably refuses, not a good idea, and attempts to ride away, but Mountain grabs the bridle of his horse, brandishing a pistol, and promises him, deliver, or I'll cool your porridge. The entire account is colored by this bravado, and even more than 200 years later, it's not difficult to imagine why this execution narrative would have been popular in its own time. But we know a lot more about the life of Joseph Mountain than we do about almost any other poor, black, indentured men from the 18th century. At the end of the 18th century, the United States had just recently transitioned from colony to republic, but a republic, of course, that that itself relied on colonial violence and land theft, such as that of the Lenape or Haudenosaunee Confederacy land, the land that we're all on right now. Most people were poor, and most people could not read and write. The technology necessary for printing was more available than it had ever been in the United States, but print in general was not available in the way that it is now. People often kept records of their lives in small, extremely localized ways, writing down birth and death dates in the family Bible, keeping diaries and journals, writing letters, etc. Poor, indentured, or enslaved people often did not have access to these kinds of record-keeping technologies, even when they could read or write. So when we have a lot of information about poor people from the 18th century, it's often the result of their encounters with major structures of power, courts, prisons, hospitals, or schools. So the reason that we know so much about Joseph Mountain then, due to his encounters with the criminal justice system. His narrative is a form of what we now call execution narratives, a precursor to true crime, and according to many scholars, a major influence on the emergence of the novel as a form of popular entertainment. Execution narratives told the life stories of people who were about to be executed for crimes. They were often sold in packets with the life story of the condemned person bound with a transcript of their dying confession, their interview with a minister on the way to their death, or eyewitness accounts of their hanging. Execution narratives were often extremely didactic, and for most of the 18th century were almost never written by the condemned person themselves. As gruesome as it is to think about now, public executions in the 18th century were something of a social event. Hundreds, sometimes even thousands of people would flock from miles away to listen to the sermon that ministers would give before the execution and to watch the execution itself. So it's important to note also that despite the fact that we know that Mountain could read and write, there's no way of knowing whether or to what extent sketches of the life of Joseph Mountain, and specifically the first-person narrative embedded within it, reflects the experiences or voice of Joseph Mountain, the actual person who was convicted of rape and executed in New Haven. While Mountain's narrative stands out among contemporary gallows literature, in part due to its distinct writerly voice, and it really does stand out in this way, criminal accounts attributed to the condemned were generally produced within the context of, as Caleb Smith puts it, coercion, collaboration, and ventriloquism. So whether or not his narrative bears any relationship to the life of the actual Joseph Mountain, the fact remains that this publication was enormously popular, and accounts of both Mountain's early life of crime and the rape for which he was ultimately executed were reprinted in newspapers as far away as New York City. And that's a big distance back in the 18th century. Upon returning to the United States in 1790, so this is after he's left his ship and had this incredible sort of life as a highwayman, after an absence of over 20 years, Mountain arrives in Boston and immediately sets out for New York, stopping in Hartford on the way. In Hartford, he stole $5, quote, from the cabin of a sloop lying in the Connecticut River, and he, quote, was immediately apprehended, carried before George Pitkin, Esquire, so the judge, and adjudicated to be whipped 10 stripes. This was the first time, he tells us, I was ever arraigned before any court. No event in my antecedent life produced such mortifications as this, that a highwayman of the first eminence, who had robbed in the most capital cities in Europe, who had attacked gentlemen of the first distinction with success, who had escaped the King's Bench prison and Old Bailey, another prison, that he should be punished for such a petty offense in such an obscure part of the country was truly humiliating. Mountain's first experience of capture and conviction was, in legal terms, relatively uneventful. He's caught, arraigned, and whipped 10 stripes. He's neither jailed, fined, nor held, and, at least according to the narrative, he's dismissed almost immediately, such that he's able to arrive in New Haven the following evening. Despite the lack of legal ramifications, however, the incident appears to land a nearly fatal injury to Mountain's pride. Indeed, his stated embarrassment at his arrest in East Hartford smacks of something that looks a bit like cosmopolitan snobbery. Not only does he get caught, but he bemoans getting caught in such an obscure part of the country. In England, Mountain's criminal prowess had made him almost famous, but in small-town Connecticut, he's arrested, whipped, and humiliated. And it bears mentioning that throughout his narrative, Mountain does makes a lot of comparisons between the way that black men are treated in England and the way that they're treated in the United States. And this is not to say that there wasn't racism in England or that there wasn't slavery in England. Both of those things absolutely existed. But it is to say that the racism worked differently. This episode directly precedes his account of the crime for which he's eventually executed, the rape of a young white woman. According to the narrative, the rape actually occurs the day after he's dismissed from his arrest and whipping in East Hartford. Mountain actually insists that he did not, in fact, rape the young woman, and which I might add is very rare to find in these kinds of narratives. Remember that there was a high level of clerical control of the press, and this is the only narrative I've ever seen in which someone says that they didn't do it. Although he admits that he taunted and humiliated her. He recounts, quote, that I abused her in a most brutal and savage manner, that her tender years and pitiable shrieks were unavailing, and that no exertion was wanting to ruin her, I frankly confess. It was a most cruel attack upon an innocent girl. When her cries had brought to her assistance some neighboring people, I still continued my barbarity by insulting her in her distress, boasting of the fact and glorying in my iniquity. Upon reflection, I'm often surprised that I did not attempt my escape. Opportunity to effect it frequently presented before I was apprehended. Yet, by some unaccountable fatality, I loitered unconcerned, as though my conduct would bear the strictest scrutiny. While here Mountain makes this assertion with something like bravado, he does appear to be bragging of his own callousness. Perhaps more intriguing is the question with which 21st century readers, graced with the hindsight that comes with an historical awareness of the disproportionate persecution and prosecution of black men, especially when it came to the cases of sexual assault against white women, are left with. How could Mountain ever assume that he would not be suspected of the crime, even as early as 1790, and even in rural Connecticut? Mountain was convicted and sentenced to death, but between his conviction and his execution, he registered a clemency petition with the Connecticut Assembly. In it, Mountain offers to be sold back into slavery or castrated as a commutation of his sentence. So just what you know, what this looks like. Sorry, I changed the order here. So this is what the actual document looks like. It's handwritten. But I put it up here so you guys can read it. It took me probably 2 hours to transcribe that, so I won't subject you to that. So just so you know what you're looking at, it says this, the relevant part says this. He would humbly submit to your consideration whether if he were ordered into confinement in Newgate, so a prison, during life and subjected to hard labor, or sold into some country where the severity of the master effectually prevents any atrocious crimes in his disposition, and the avails of such labor or of the sale of his person given to the injured girl, it would not be as advantageous to society as the taking of his life. Should such a measure be thought undesirable on the ground that he might hereafter commit like crimes, he would even submit to be castrated rather than suffer death. So as I begin to conclude, I want to offer a crash course on early American rape law. There's a lot to be said about this, and I can in no way do justice to the incredible scope of this legal history in this short presentation. But let me offer you some basics. And so I'm going to go back. As we know, the United States as a nation grew out of a system of connected British colonies at the end of the 18th century. While it took some time to develop federal laws, the laws that govern the nation as a whole, individual colonies had their own legal structures more or less since their inception. And these legal structures were more or less direct importations of British law because the colonies were British colonies. Put differently, colonies like Connecticut or New Jersey more or less had the same laws as England because it was written into British law that its colonies would be governed by the same laws that governed England. This includes laws around sexual violence. In the 18th century, there was a pretty big swath of terms that described sexual violence, including rape, ravishment, seduction, sometimes buggery, and more. But the way that we usually see these behaviors written into law and prohibited was under the auspices of rape. That said, it's important to understand that it was extremely difficult to make a successful rape claim in early American courts. As Sharon Block, who's a historian of this subject, argues, quote, men were supposed to be sexually aggressive, and because of this, consensual sex could contain violence without being classified as rape. And because early Americans theoretically expected respectable women to resist all illicit sex, so sex outside of marriage, men could substitute their own judgment for women's consent. This made women as a group unreliable witnesses to their own resistance and left them very little room to show the true opposition necessary to prove a rape. Rape, by the way, was a capital crime. The punishment for rape was death. Another thing to know about the laws of early America, while most of them were imported from England, many of them were imported and then adapted or amended to address the specificity of life in the colonies. One of the biggest departures from British common law and penal codes then arrived with the development of what historians now call slave codes, which were basically addenda written into extant laws that specifically governed the behaviors of all enslaved people, often also including free people of color and indigenous people. Importantly, all of the slave codes that I've looked at so far from various colonies specifically address rape. So there's that one. Specifically address rape. And these slave codes often lay out different sentencing guidelines for enslaved people and people of color who rape or attempt to rape white women, and sometimes even set up entirely different courts for the adjudication of crimes. This affected what Block calls a racialization of the law. So slave codes developed a secondary structure for the adjudication of crimes, including rape, that laid out separate standards and separate penalties for the same crimes based on the race of the offender. While this is still with us today in practical terms, we know, for example, that in states that still have capital punishment, black people who kill white people are many times more likely to be sentenced to death than white people who kill black people. In early America, this was explicitly written into the law. The differential did not end with the British control of North American colonies, however. As colonies became states, most colonies in which slavery was still legal simply ratified the colonial slave codes as the new law of the state. See, for example, the laws of the state of New Jersey, which were written by someone who will be familiar to all of you. So these were written by William Paterson. And so this is the beginning of the section that details the slave codes. So I'm going to conclude by pointing to one of the big differentials enacted by many slave codes, which is that one of the punishments reserved for enslaved people, which by 1800 almost exclusively meant people of color, convicted of rape, was castration. It is true that in some states, white men were at times castrated as penalties for various offenses, so castration was not a punishment exclusively reserved for enslaved people, but is explicitly written into a number of slave codes, such as this one. And this is the slave code from colonial New Jersey, written into the law right at the beginning of the 18th century. It's very clear. If any Negro, Indian, or mulatto slave shall attempt by force or persuasion to ravish or have carnal knowledge of any white woman, maid or child, he shall be castrated. So when Joseph Mountain entered a commutation petition in the Connecticut State Legislature in 1790, asking to be castrated and sold into slavery, and again, remember that he had never actually been a slave, in exchange for his life, this is the legal context he was invoking. While this is disturbing, what is perhaps even uglier is the fact that castration only became a mitigating penalty for enslaved people convicted of rape because, as Diane Somerville suggests, when colonies or later states executed enslaved people for rape, in many states the courts then had to reimburse the slave owner for loss of his property due to chattel slavery laws. Castration was a mitigation of the legal penalty for rape, but it may have been developed in part because it also mitigated state expense. I think what was most disturbing to me when I first read Mountain's commutation petition, and I have found at this point 6 others like it, of enslaved men asking to be castrated or sold into slavery in exchange for their lives, was the experience of watching Mountain bargain for his life at the expense of his body and specifically at the expense of his testicles. And in reading this petition alongside slave codes that prescribe castration for not only enslaved people convicted of rape, but also for enslaved men who were high-spirited, contrary, or incalcitrant, we can see the way that this punishment reflects the way that Black men's sexuality has historically been targeted by both legal and extra-legal structures as a site for discipline, or, put differently, harm. This is sexual vulnerability. It is no accident that the law and the culture that sustained it trains its gaze, then and now, on the genitals of Black men. And in case any of you thought that this story represents a relic of an antiquated racist past, I want to mention that the use of castration to punish sexual offenses is still with us, in the form of, for example, sexually violent predator laws, which are currently on the books in more than 20 states, that allow for the institutionalization of people imagined to be dangerous, even after they have served their prison time, or laws in 8 states which provide for the surgical or chemical castration of people convicted of sexual offenses as an option that reduces prison time. I think we can see in these legal structures another form of sexual vulnerability, the shadow side of the rape law that was designed to protect all free women from sexual vulnerability, but that in practice distinguished between which women could be understood as vulnerable, white, usually wealthy women, from those whose vulnerability was refused, enslaved women and men, free people of color, poor people, working people. I argue here that early American rape law in fact produced a range of other forms of sexual vulnerability, and in particular that of Black men. This is not to say that Joseph Mountain's actions, if they were what we are told they are defensible, but rather to say the way that we address the very real problem of sexual violence has historically created multiple forms of sexual vulnerability that I think are sometimes difficult to recognize. Some of this is due to the fact that both brownness and Blackness are already more intensely surveilled, so anyone accused of sexual violence who's Black or brown will be more readily convicted, either in the criminal justice system or in the public eye. But I wonder what would happen if we shifted the frame away from thinking about sexual violence as more or less a binary relation, there's a perpetrator and there's a survivor, and thought instead about the multiple forms of sexual vulnerability that the combination of, on the one hand, both historical and current legal architectures of rape, and on the other, racism, have begotten. What political alliances between white women and Black men, for example, might emerge if we think this way? Might the Metoo movement be an especially powerful site for the articulation of an anti-racist politics? What I hope these histories can teach us then is to demand a more systemic analysis of these moments and demand justice, and to demand justice in the key of us too, not just me too. Thank you.
Thank you so much. I learned so much from that talk because I'm not a historian and I don't actually have any of this context. So our next presenter is Professor Durba Mitra, and I'd like to welcome her to the podium now. Your opening slide is next, and I'll be sitting right there with the signal.
Okay, great. Thank you. Thank you so much for this day, and thank you so much for being here. This is such an exciting opportunity for me to speak about a different place, but in some ways issues that will relate very much to thinking about Me Too here. And I just want to take a moment to thank the organizers of this fantastic day. And I'm just going to thank the committee very broadly, and the co-chairs and Dean Rabbit and Associate Dean Davis for having us. This is really an extraordinary moment because we have a full day of sustained conversation about an issue, to think seriously with you all about what it means to think about Me Too, its successes and failures, as we'll hear later, but also the history of it. Is it new? I'm going to speak today from a different perspective, but first I want to ask you, what does it mean to remake our world? Today I want to think with you of the future that was, a set of social movements that sought to imagine a different future through mass mobilization, speaking, fighting against sexual violence and sexual harassment. Today, we have a very different moment of mass mobilization, one where we have to ask ourselves, where do we go from here? So I speak to you as a scholar who works on the region of South Asia, which today is the nations of Pakistan, India, and Bangladesh. Some of you may have seen recently that there's been a lot of Me Too movement in that region of the world, especially in the last few weeks among the Indian media, just a year after the movement emerged here like wildfire. I want to use some historical examples, because I'm a historian, and bring it to bear on some contemporary issues from South Asia to give you an understanding of how the Me Too movement has a global valence, and how movements against sexual violence have been significant to global feminist movements for decades, and how in a region of the world, South Asia, that is 1/5 of the world's population, we can think of Me Too as much, much broader than, our Facebook feeds and our Twitter feeds. I also want to put forth an argument to you about how we might think about the examples from South Asia to examine what's happening here. My examples are built on the work of many prominent feminist scholars, and I'm just going to name them at the outset, people like Mary John, Nivedita Menon, Pratiksha Bakshi, Prabha Koteswaran, and I'm naming them in case you're interested in reading more, who have worked extensively to think about sexual violence, the state, and its significance in South Asia. I'm speaking at length about sexual violence, as Greta did, as Professor LaFleur did, because as you know, the Me Too movement is one that encompasses a wide spectrum of behaviors, from sexual harassment to sexual violence. And because the very idea of laws against sexual harassment come from mass mobilizations for laws against rape and sexual violence for many decades and centuries before. So today I'm going to talk about three major eras. The first is in the early 1980s, when protests break out both in India and in Pakistan against laws that structure crimes of rape specifically, but more broadly sexual violence. The second is the Delhi gang rape case, which happens in December of 2012 and leads to protests and massive transformations in 2013. A terrible event that breaks open a political opportunity for organizing against sexual violence in India, and which leads to substantial changes in the rape law. And then I'm going to speak a little bit about sexual harassment law today and the Me Too movement, focusing in part on a terrible tragedy, a tragic rape case that just happened in 2018 in the disputed region of Kashmir, in Northwest India, or South Asia, I should say, and then sexual harassment law today and ongoing fights for Me Too. So let me give you three arguments to structure and to think with, not just thinking about India, but more broadly today. The first is, how can we think about political movements and what they reveal for us for the power of evidence? The very notion of what counts as evidence, particularly when it comes to sexual harassment and sexual violence, and that biases exist in the very practices that we see as objective, those practices like an FBI investigation, we might say, that we use to understand the truth behind the crime. The second way of thinking that I'd like to think with you today is that political protest and claims to changes in the law usually focus on criminal law, and we saw that in Greta LaFleur's presentation as well. And can we think of a fortification of criminal law that does not fortify the carceral state? Put differently, I want to take these movements to think with feminists who have and continue to organize to reform law and regulations to protect vulnerable subjects around sexual harassment and violence, but have done so in opposition to police brutality, police violence, and the ways in which states make claim to absolute power through laws against sexual violence, as we saw in Professor LaFleur's case. In speaking, and to speak again in line with the last presentation, I want us to think expansively about who is sexually vulnerable. And I hope that, especially in the Q&A, that we can talk a little bit about this, so that we consider a different mechanism, and I think that has happened a lot in the Me Too movement here to some degree, that's not only about men versus women, but to think about sexual minorities, gender fluid, gender queer people, LGBTQ communities, for whom shame has been such a central way in which sexual violence has shaped their life. So I'm just going to give you just a tiny bit of background. In India, the rape law, and I should say colonial India, which now encompasses Pakistan, India, and Bangladesh, the rape law was introduced in 1861 in what is called the Indian Penal Code. And rape law has only substantially been amended twice in India since then. So 1860 it was passed, and then it was changed in 1983 after a huge political mobilization, and again in 2013 after the Delhi rape. I could say a lot about the law against rape, but the key is that in the first version of the law required demonstrating that rape was by a man of a woman, and it required the penetration of a penis into a vagina. So the law explicitly stated, so it was not organized around the conception of consent, but you had to demonstrate that there was the forceful penetration of a vagina by a penis. Now that changes under the 2013 law to say that it's still gender specific, meaning that only women can be raped in South Asia, but that it now is not just penetration by a penis. And I'm being very explicit just because this is the legal structure. So let me start with the Mathura rape case, which happens in 1979. In the 1980s, well, to be exact, in September of 79, the Indian Supreme Court decided on a rape case in favor of the defendants for a case that had gone through the lower court. So it had gone all the way up to the highest court in the land. The case concerned a girl. And I'm saying a girl because she was somewhere between the age of 14 to 16, a woman who goes by the name of Mathura, who was held in police custody after a dispute related to her own sexual relationship with another man. I gave you the date 1979, but the rape occurred in 1972. And it took a full 7 years for the case to appear before the Supreme Court for final adjudication. So in 1979, a set of 4 lawyers wrote an open letter to the Indian Supreme Court declaring their decision to be prejudicial and against human rights because they decided in favor of the defendants. The letter and the people who authored the letter spurred a mass mobilization. In the Supreme Court decision in the Mathura case, judges stated that the woman, Mathura, did not have enough physical evidence to demonstrate that she had resisted rape. And second, that she was, quote, habituated to sexual intercourse. Habituated, it was a habit. The Supreme Court overturned the conviction of her accused rapist and declared that Mathura was lying, that the Supreme Court held that the woman had raised no alarm, she hadn't shouted enough during the rape, and that there were no visible marks of injury on her body, which means that she had not struggled against her accused rapists. That one of the judges noted, quote, because she was used to sex, she might have incited the police, they were drunk on duty, to have intercourse with her. The protests that followed were carefully curated and organized, including one of the lawyers who authored the letter, Lotika Sarkar, who started the Forum Against Rape in 1980. They led to legislative transformations in rape law, but no changes in particular to the Mathura case, so that case still stood. Those men were acquitted. And particularly as it related to evidence, the legislature declared that victims that the court had to presume that the victim was telling the truth to the degree that she did not consent, and it made specifically custodial rape, that is rape in police custody, a crime. But the material conditions of the woman's life, Mathura, seen here with the prominent feminist activist Seema Sakare, as you can see on the right, that a poor woman, a woman from poverty, an indigenous woman, she was from a tribal community in Western India, from a rural space, that there was basically no system of justice for people like this. She lived with a legacy of not only rape, but also the publicization of her rape and the political mobilization of her, so her face, her name was everywhere. And the knowledge in her community and afterwards that she had been raped, and the relative impunity of the state and the police in those regions. In the aftermath of the protests, as I said, some of the laws changed, particularly in criminalizing the police and custodial rape. But the premise, the very idea that a woman could be, quote, habituated to sexual intercourse had come from the medical evidence or forensics. And we talk a lot about, there's a lot of forensics in CSI and so on. But in fact, the prejudice was held within the forensic medicine itself. And came from the medical evidence, false claims to virginity, and the law around that medical evidence actually quite still stands. And the status of evidence of things like a woman's hymen and her virginity, in particular to determining rape, continues to influence rape cases in India. I want to turn to a second instance. I wanted to give you some visualizations of the mobilization. This image is kind of an iconic image of this Mathura moment. The second case I want to turn to, which is in 1983, is a law of evidence protest which happens, and this is again to point to the question of evidence, in Lahore in Pakistan, led by the Women's Action Forum, a set of educated women's lawyers, middle class to elite women, against what were called the Hudud ordinances. In particular, what was called the law of evidence, which said the testimony of 2 women was equivalent to the testimony of 1 man. The protest was bigger than the particular idea, as well as the Hudud ordinances passed under a military dictator who rose to power in 1977. Zia-ul-Haq had the language of so-called Sharia or Islamic law to pass draconian rules about rape and sexual violence. The Hudud ordinances are very diverse and quite specific, but I'll say that if a woman was raped under the Hudud ordinances, she required 4 direct male eyewitnesses to prove the act. If she made an accusation without being able to conjure 4 direct male respectable eyewitnesses, she would be convicted of falsely accusing rape and would be charged with bringing a false charge of rape and for having extramarital sex. So any form of extramarital sex, whether it is adultery or rape, was criminalized under these laws. So what happens is that 400 women came together, if not more, women, like I said, these lawyers from the Lawyers Association, with the intent of carrying a petition about the law of evidence from Lahore Center into the High Court. As they came together in protest and began to walk there, hundreds of police officers descended on them. The women stood up to protest, and the police broke up the demonstration. They used tear gas and batons on the women, injuring women and arresting 50 others. And pictures of the women being beaten were plastered all over the media, and it stirred a new movement for women's rights under an authoritarian regime, a dictator, essentially. These women were condemned as un-Islamic, despite the fact that they had sought to protest this law all the way through, many of whom were in fact observant Muslim women. And so again, we see a protest, a mass mobilization based on the question of evidence and what it means for a woman to say that she has been raped. After the controversy, the Women's Protection Bill eventually gets passed, but only in 2006. Okay, so the laws are passed in 1979, and they exist all the way until 2006. And when new laws are passed in Pakistan in 2006, what they do is they reinstate the rape laws that we see in India before any of the reforms. The last case I want to give you is the Delhi rape case. Okay, so on December 16, 2012, a woman and her friend left a Delhi mall. They had gone to see the movie The Life of Pi. They boarded a private bus because it's very difficult to get public transportation in Delhi, where 5 men subsequently raped the woman, caused massive injuries to her friend, and they left them by the side of the road. The rape, the details of which I do not want to give here, was extraordinarily violent, and that is the case also for the Mathura rape case. The woman spent 13 days in a precarious medical condition before she died. And it immediately leads to large-scale protests led by students demonstrating state action against rape. The federal government didn't know what to do, and they used tear gas and water cannons against the crowds, as you can see in these images. And so we again see the police force against any kind of protest around sexual violence. The public debates after the rape case in 2012 and her murder was defined by a new and important set of debates about rape, whether it should be punished by the death penalty as it had been in the United States before. Chemical castration is also being discussed quite a lot in contemporary India. The federal government appointed a commission to revise the law, and that commission received 70,000 public submissions about how to revise the law, because clearly people are interested in what it means to think about sexual violence today. However, eventually the legislature in March of 2013 does basically only part. It puts together a watered down version of the law, and it doesn't include many of the provisions that this commission recommends. The big two differences is that it changes the law to not simply be the penetration of a penis into a vagina, but it still made it gender specific, meaning that only a woman can be raped. But now the perpetrator, the other person, the person who's being accused, can be of any gender. So in this moment, we see the expansion of definitions of criminal law, a turn towards the state to create a sense of justice related to sexual violence. In the mass mobilization that happens after the rape, the message was clear. We seek not just justice, but the death of anyone involved in such a crime. So in the moment of mass mobilization, we can see a different makeup than the images that we saw in the 1980s protests. In fact, if we go back, you can see that there are huge numbers of men protesting, and I think this is the first time you see this kind of number of men protesting against sexual violence. So when men join the protest, we see much more of a call for police enforcement, for state intervention, and the expansion of the carceral state. Feminists eventually are critical to preventing the death penalty from being included in the law revision. So the death penalty is still not not a punishment for rape in India. So the decision has led to critique, though, from positions of LGBTQ people. Feminists, in fact, were quite integral to making sure that the law was gender specific, that women are the only people who can be raped in India. And LGBTQ people, especially third gender, or what is known as the Hijra community, were quite appalled at what happens with the reform of the law, because what the law says right now in India is that there is no way for LGBTQ people to be sexually assaulted except through a heterosexual assault. Legally, the win for transforming the law by feminists and protecting women as a special category has meant sacrificing the possibility of millions of people who identify otherwise. So let me turn briefly to today, and you can get a sense of the vastness of the protests. The most recent rapes to spark widespread outrage, as we see, was of 2 minor girls, which happened just in 2018. One was in the disputed territory of Kashmir in northwest India, South Asia, sorry, and the other was by a government official in northwest state of United Provinces. I want to mention these two because, again, we see very complicated questions of the place of the state as a perpetrator of sexual violence, of Kashmir in particular, a disputed territory where people basically have no rights whatsoever, and are governed under what are called emergency laws. And so all of the rape reforms that have happened around 2013 and 1983 do not apply in the region of Kashmir. So I think it also speaks to the limits of this cycle that I'm trying to identify for you all, that we see again and again. A rape happens, a big event happens, it gets lots of media coverage, there's a mass political mobilization, and then there's a legal change, and then there's just this lull. So we see this kind of cycle happening again and again, and I'm using the India example, but you will see this in many parts of the world. If rape is still happening at an alarming rate, then what are those mass mobilizations doing? I want to mention also the Metoo movement in South Asia, which has been really substantial. I'm going to come back to this slide. So this was actually an image that Professor Raghavan very kindly pointed out to me on Tuesday of this week. This is Metoo right now, this week, blowing up on Google Trends. Just to give you a sense, these are the searches that are happening in the United States on the right, and these are the searches that are happening in South Asia. Okay, so South Asia is literally blowing up, right? We can see that Metoo as an idea is really like wildfire. I think the Me Too movement in South Asia, especially among elites, among English-speaking people, has been transformative. What we do know is that the Me Too movement is not solely one movement, it's a fault line, it's multiple movements, it's moments, it's forms of speaking that has transformed our imagination of sexual harassment and sexual violence. As we speak, in fact, yesterday, a key national minister resigned after multiple accusations of sexual harassment and assault. Finally, I wanted to note that sexual harassment law in India was guided by 2 forms. One is the sexual harassment of women in the workplace, a law that's passed in 2013. The second is a provision that's in the criminal law, kind of like the rape law, which was part of my title, which is, quote, the outrage of a modesty of a woman. So that language, which doesn't look so different than the ravishing of a woman in the 18th century, it's the same kind of colonial language, is still in the criminal code. But what does it mean to outrage the modesty of a woman? And in fact, who gets to be the people who are outraged in this circumstance in some ways? Who gets to be a modest woman? And what does it mean that there are no forms of laws against sexual violence and sexual harassment against LGBTQ and trans people? Most importantly for our discussion, how do we think about laws against sexual harassment in the United States and elsewhere? For South Asia, where people are 90% of them work in the informal sector, which means that laws that govern sexual harassment do not apply to them. And so I wanted us to think a little bit about what the domain of law really does for us. I started the talk today to ask you, what does it mean to remake our world? Very few of us know very little about the sexual harassment laws here in the United States. How many of you have read Title VI? Yeah, I mean, it's really, really comparative, like interesting reading, perhaps not. It's the equal opportunity employment law against sex-based discrimination that's defined really by one feminist, which is a woman named Catherine McKinnon. Few of us also know, although we hear more about Title IX, which is also written in collaboration with Catherine McKinnon, which governs sexual harassment and violence in educational institutions. Title VI only reaches formal employment places and housing law. Title IX, as I said, educational institutions. There is no provision to address sexual harassment in immigration law at all or related to immigration centers, which means that an ICE facility functions with a high level of impunity. We know that immigrants have no access to the rights of due process for citizens. We see this over and over again, especially in the last 2 years. But we have little grasp of what I imagine are extraordinary conditions of sexual violence and sexual harassment under positions of incarceration in ICE facilities and otherwise. And that educational institutions, and this I think is really critical, educational institutions only have to demonstrate that they were not deliberately indifferent under Title IX when one files a Title IX case. So you have to show that essentially they paid attention to the case when you file a Title IX case, meaning they simply they have to do some sort of investigation. So not unlike the United States Senate, they can say we were not deliberately indifferent. But they do not have to show the transparent due process. There's no true pursuit of justice, in this case for the accuser. And it is this history that I wanted to use South Asia, that we might take a page to think seriously about what it means to think about the carceral state, incarceration, and thinking together not simply about Metoo and what it means to speak, but what institutional redresses we seek in the aftermath. Is that through criminal law? If so, what are the laws that we desire? One of the things that we've learned in the United States is that a mass mobilization does not necessarily change politics. The women's marches, multiple as they are, have caused essentially no legal changes. In fact, I would parallel the mobilizations that we saw here most powerfully to Ferguson and the Black Lives Matters movement. But what I feel we've learned from Ferguson, and I do not mean to say this pessimistically, but with reality in mind, is that there has been little legislative change. So in the case of India, we see, right, an event, a mass mobilization, and some change to the law. But in the United States, that mass mobilization does not necessarily lead to a change in the law. What that means is that we have to think about what does lead to legislative changes. And that means that here we have to link voting rights, because it is in some ways only voting that really transforms what the legislature is. So we should link voting rights to what is happening with Metoo and sexual harassment. That means maybe one of our takeaway lessons from what I spoke about today is not simply to march or to take to the streets as these amazing social movements have done. It means to ask what version of politics have worked for us with sexual violence and what lasting public discourse will affect change. I wanted today to give you this history to tell you of a future that was imagined, a future that was, a different society that mass mobilizations of people sought to imagine for themselves, a future that's construction is ongoing today and that is critical. The effort of William Paterson today, I think, really speaks to this moment, to take one day to think about our own futures, to think outside of a politics of carcerality and the police, to think together about what it means to speak our truths and think with the past of what might come after. Thank you so much.
Wow, thank you both so much. What fascinating presentations that really give us some context and history for these questions across the globe and right here in New Jersey. Before we proceed to our question and answer, I do want to take a moment to recognize and thank Acting Provost Sandy DeYoung for joining us this morning. And for all others who joined us during, welcome, and we hope you enjoyed the morning's panel. We're now ready to continue this conversation with your participation. Let's take some questions. Is there anyone that has general questions, things they'd like to add? Food for thought.
Okay.
We have one over here. Could you raise your hand again?
Good morning.
Good morning.
This is actually just kind of an addition to Professor LaFleur's talk about how a minority man was subject to majority laws. My main field of study is actually Japan, and I don't want to. Oh, sorry. I couldn't help but be reminded of a similar-ish case that happened in Japan in the late 50s to early 1960s. There was an ethnically born Korean teenager in Japan named, at least the Japanese pronunciation is Ri Chinu, and he was convicted of raping 2 Japanese high school girls. And kind of like Mountain, since the 1960s, he was literate and everything. But many intellectuals in Japan at the time, Ri actually wrote about his experiences as a child growing up in Japan as a minority, as an ethnic minority, feeling discrimination in the employment sector and things of that nature. And many intellectuals at the time, like filmmakers and literary figures and playwrights, they all found something in this one case that greatly affected much of the media in Japan in the 1960s. Not necessarily in that highway robbery kind of way, like it was romanticized with Mountain, but at least I saw some parallels in between the two. And I unfortunately don't know if his diaries are translated into English or not, but I know that if either of you want to experience it, I guess, I highly recommend Death by Hanging by Nagisa Oshima. His, thankfully that's available in a very good English translation. And they were also, and he eventually was put to death by the state, very similar to Mountain. But I think that, at least on the surface, those two stories seem very similar, even though they were 1.5 centuries apart in different continents.
Sorry, I have to pause you for 1 second. Do you have a question that you wanted the panelists to address?
I actually do. Hold on. I'm very long-winded, I apologize.
That's all right.
But compared to other feminist movements, it seems that there are no radical, I don't want to call them ideologues, but no radical major figures like in the past. Whether in the US or India, it seems that leaders are more well-off and can afford to speak up. Unlike past feminist radical minority leaders such as Angela Davis, for example, it seems there are no poor or minority women that have prominent places of leadership in either country's movements. Do you know what, if any, efforts either American or Indian leaders have tried to include minority women in further discussions of the Me Too movement?
Do you want to take the first?
Either one of them.
Oh, I'm also able to speak to the United States, but please go ahead.
Oh yeah. Well, thanks for your question and your comment, and I'll look up that film. I think that there's a couple things. I think part of your comment part of your question speaks to the way that that movements are forming right now. I think with the this is just a sort of background statement about it, but I do think that between social media I think there's a sort of lateralization of the way that politics works in general right now, and a particular kind of politics in particular. So this is just to say that it's not that I'm saying that that's not true, but I do want to say that I do think there's something about the way that political organizing works right now, where we see less of like a sort of like singular voice, although certainly in that moment there weren't singular voices either, right? Angela Davis was one of many activists who were working towards lots of different types of change. But I also I take your point around also the particular architecture of the Me Too movement, and I think about like the people whose voices have been sort of propped up, and certainly, I mean, I think about, especially in like the entertainment industry, we see a lot of, like, I think about like Ashley Judd, for example. We see a lot of either like white presenting or white women speaking on behalf of this movement, and I do think I think that one of the things that, as someone who works on the history of the 18th century and thinks about feminist politics now, that we can see is one of the ways that that rape claims have this kind of legitimating function in terms of shoring up particular visions of respectable womanhood, and I think that there's absolutely a way that even among all the other good things that I think that anti-sexual violence movements have done, and I think they've done amazing important things, there is a way that they're also about making whiteness and making white femininity in particular. And so I guess that's one of the things I'm hearing in your question. So I think it's a good one.
So I would say, Tarana Burke recently had a piece in the New York Times about the fact that a year ago, this movement started, which was taking the hashtag #MeToo from a set of political interests and political questions that she's been asking for the decade before. And one of the things that was interesting about her articulation of it is, in some ways, she described that, when she started to see the hashtag, she was worried that she was not going to be credited with the movement, and then eventually people credited her kind of in a very complicated way as a founder, but kind of in some ways a dislodged founder. And one of the things that has been interesting in the aftermath is that in some ways creating one face for this movement looks a lot like, I think, a lot of political movements right now. There is no one face, because that's the nature of the movement. It's Me Too. And so when Professor LaFleur says us too, it's actually hard to imagine what it looks like, because it's not one movement. And so it gets complicated to think about a leader in that circumstance. It doesn't look like the deliberate protests of the 1980s that we saw in India. And the other thing I wanted to mention from the example that you brought up in Japan, which I think is excellent, is that, the ethnic minority as the person accused of raping the majority, the person who's supposed to be protected, that vulnerable subject, that's, sexual violence is that fault line. It is race, it is, in the context of India, caste and religious difference, and it is an extraordinary tool on both sides, right, to foster hatred and communal violence or violence between communities, as much as it is to think about who's vulnerable in our world. One of the things that's happening in India, and not just in India, but in Pakistan and in Bangladesh, is that right now on social media, especially on apps like WhatsApp, there have been a lot of false rape accusations, or accusations of Muslim men who have sexual relationships with Hindu women. And there are rumors that circulate, and it has led to really very visible and very, very horrific public lynchings. So again, if we think about the parallel histories of the way sexual violence in particular is a fault line to think about violence, racialized violence, and in the context of India, religious or caste-based violence, this is why I think all of us today study these questions, because sexual violence is such a critical nexus point for these questions.
Yeah. Thank you both so much. We actually have to conclude our panel for this morning, but I really appreciate both Dr. LaFleur and Dr. Mitra for giving us so much to think about. I was thinking a lot about your question of who is vulnerable, and I leave you with that.